Hello everyone, welcome to Krishna's Lawrials YouTube channel. I am Sonali, one of the educator who is going to take LLB first semester classes this time. As you all know, Krishna Lawrials has been presenting classes since 2 years. Even this season, we are back with first semester classes. Those who all are interested can join the WhatsApp community link provided in the description box. Also, you can gather more information about the course through the website link provided same there. Currently, there are many discounts going on. Interested students, kindly hurry up. Yeah, thank you in advance. In today's introductory demo class, I'm going to deal with the first paper, that is Law of Contracts. So here, before going to the subject, I have certain things to specify. That is, first I'll be giving you all an overview of what law is and who makes the law. After that, we'll be getting into the introductory part of the Indian Contracts Act. Then two of the main definitions, that is the definition of contracts and agreement, I'll be taking up. After that, the essential ingredients of a valid contract, which happens to be an important answer, we'll be dealing in this introductory class. So let us begin. Now, imagine you are driving your car on a highway at the speed of 100 kilometers per hour. Okay, but the rule is you are supposed to maintain the speed of, let us say, 50 kilometers per hour or something like that. Okay, so what happens when you don't follow the rules and regulations? You all know what are the consequences. It leads to accident or you will be fined. All of those things comes into picture. Understand one thing, rules and regulations, the term which I am on emphasizing again and again, is connected in every situation in which we are. Okay, somewhere or the other, we all are working under rules and regulations. Okay, if I am a student, I am supposed to reach college by so and so time, say 10 a.m. Or if you are an employee, you are supposed to reach your office at 9 a.m. sharp. So rules and regulations, every organization, or for that matter even every house, has certain rules, right? But rules in common, okay, say in our state or in our country, who makes rules and regulations? That is the question mark here. Now, laws are nothing but rules and regulations framed and imposed by an authority. Now, this is the basic definition of law, I can say. Any sort of rules and regulations are nothing but laws. Who actually frames these laws? I need to say you something very important. So here, any government comprises of three organs or three wings. Okay. So the first wing or the organ is the legislature, whose work is to make or frame laws. Okay, so what is the legislature, you might ask? Legislature is nothing but the parliament, which consists of Lok Sabha and Rajya Sabha, and at state level, if you see, the legislative council and the legislative assembly. Okay, the work of these institutions is to make or frame laws for the public, okay, within the state or within the country. Now, the work of the second wing, that is executive, is to implement the laws which are made by the first wing, that is legislature. Okay, now implementation part, in the sense that all the government servants, okay, their work is to implement the laws which are made by the legislature. So as I have told you, I will give you another example just after the completion of this sentence. Now coming to the third wing, that is judiciary. The work of the judiciary is to provide justice to all. Apart from that, if there is any ambiguity in the sense, if there is no clarification in any of the law, so that clarification or clarity is provided by the judiciary. Okay, so interpretation of the law. Okay, interpreting in a so as to make it more understandable is the work given to the third wing, that is judiciary. We say judiciary is the independent organ. It is not at all dependent on executive and legislature. Okay, now coming to the example which I was talking about. Say you are driving your car on a road. All of a sudden you want to park your vehicle, your car, and there is a no parking area there, and you have parked your car there. What is the scenario? Your car will be taken away by the traffic police people. This is because there are certain rules and regulations which are recognized and applied by the state, okay, which you have not followed. So government employee, here is the traffic personnel, okay, he comes into picture, he'll impose a fine on you or he will seize your vehicle. Okay, now this is the simplest example which I can give you of law. So it says rules and regulations framed and imposed by an authority. If such rules and regulations are not followed, then the state will impose sanction. Sanction in the sense punishment. Okay, now in law actually there are various jurists who define terms in their own language, in their own understanding, and it is important to go through their definitions. So on the term law, Salmond has given this definition. He says body of principles recognized and applied by the state to attain justice for all. Okay, so why are rules and regulations important? It is because only because of rules and regulations state can provide justice to its subjects. Okay, subjects here are the general public, we can say. Okay, now John Austin has defined law as a command which, if not obeyed, imposes sanction. Okay, so it says law is the command. If such a command is not obeyed by the citizens, then the state will come into picture and impose punishment upon them for not following the rules and regulations framed by the legislature. So such is the importance of law. Okay, yes. Now the body of principles, in short, the law which we were speaking about till now, has been categorized into two parts. Okay, now the first part we can call it as procedural law. So the first category is the procedural law. Let us suppose there is a case which has gone to the court. Okay, now all the procedures which go on in a legal proceeding or a court case are to be conducted in a proper sequence. Okay, there is a proper method which is to be followed in the courtroom by the advocate, by the judge, by the other court officials there. So why do you think is all this necessary? This is because so that justice is provided to the persons who have come to court accurately. So a proper procedure has been put forth so as to follow that procedure and attain justice. That is why we see cases just go on for years and years. This is because of the lengthy process or the lengthy method involved in the legal proceedings. Now, if you see, if a trial begins today, in the first day of the trial itself, there is no evidence which is produced in front of the court, isn't it? There will be a sequence where evidence will be produced, testimony of the witnesses will be taken. All of that proceeds in the way like that. So procedural law is that category under which comes the rules of evidence or the civil law or the criminal procedures. this part of law deals with only the procedural law, okay, which is also called as adjective law. Coming to the second categorization of law, that is substantive law. Substantive law, in substantive law, you can find rights and obligations of the parties involved. Okay, I am giving the example of Consumer Protection Act 2019. Say you have purchased a earphone from an online platform, and you have received some other device, so you have gave back, you have returned that particular piece, and you're not satisfied with that with the services of that online platform, so you proceeded with the consumer forum. You have gone to the consumer courts against the online platform from where you have purchased your device. So there what actually happens, the court will look into the rights of the consumers. Okay, so where will the court find? In the Consumer Protection Act, there are various rights and obligations which are specified relating to a consumer. Okay, basing upon that, the court will recognize your rights and you will be given remedies. Okay, you will be provided reliefs, I can say. So damages will be provided to you. What are damages? In legal terminology, damages has some other meaning, okay, but in legal terminology, damages means compensation. Okay, so any act which deals with rights and obligations, which specifies the rights and obligations of any of the persons, then we can say that law comes under the second category, that is the substantive law. Examples are contract law, tort law, or criminal law. These are the two categorization of the body of principles or the law, we can say. Now, proceeding to our subject, so let us understand, is an Indian Contract Act procedural in nature or substantive in nature? Now, if you look at the Contract Act, it deals with contracts, and who makes those contracts? Those people are nothing but citizens like you and me. Okay, now these parties who come together to form a contract, these people have rights and duties on each other's part. They are supposed to play a role, and for that both of them have rights and duties to perform. Okay, now it also specifies the elements which are required for a valid contract. Also, if the contract which is made by both the parties, if any of the party does not perform what is written in the contract, then it will lead to a breach of the contract. Okay, in the sense you have not followed the contract properly. Now all these things are specified in the Indian Contract Act. That is why we say that Indian Contract Act is a substantive law, because it is substantially proving, showing all these things: rights, obligations, elements which are required to form a valid contract, and also it is specifying what is to be done when there is a breach of contract, when any of the party is not conforming to the contract. Now, as I have told you, the basic principles and the nature of the contractual relationships which is written in the Contracts Act qualifies it to become a substantive law, we can say. Okay, now the scheme of the syllabus which we are going to deal in the first semester comprises of 5 units. So in the first 4 units which we are going to deal with, in the 4 units we will be coming across section 1 to section 75 of the Indian Contracts Act 1972. Okay, now the other sections will be dealing in the next semester. Okay, now in the 5th unit we are going to deal with a new enactment, different enactment called as Specific Relief Act 1963, along with its amendments which have been brought in 2018. So these are the 5 chapters which we are going to deal with. Now, getting into the introduction of Indian Contracts Act. We human beings are social animals. What does that mean? In the sense, we cannot lead our life all alone. In day-to-day life, we come across different people. We interact with many people, and knowingly or unknowingly, we get into many contracts every day. So, at home, if there is a maid coming to my home to wash the utensils or for any other such work, both maid and I are into a contract. Okay, for all the work she is performing, I am supposed to pay her salary, her wages, right? So this is a kind of contract between her and me. In the same manner, when once I am stepping out of my home, I am taking a cab to my office. Okay, there I am contracting with the cab driver to drop me at my workplace, right? So I am providing him consideration. In the sense, consideration in legal parlance is called as something in return. So here I am paying the cab charges to the cab driver. Okay, so this is the contract between the cab driver and me. That is, my right is to travel in his cab, and his right is to obtain the charges of cab from me. Okay, now, even if you're going to a restaurant to have your dinner, the moment you get into the restaurant, be seated in the restaurant, order some food. Okay, so there it means that you're contracting with the restaurant owner. He is supposed to provide you with the qualitative food. That is your right. Okay, and your duty is there to provide the charges. Okay, so this is nothing but these are all contracts which we come across in everyday's life. So here if you see, both the parties, okay, so the maid and me, I and the cab driver, here if you see, contracts are always between 2 or more persons. Okay, this is the first point which you all are going to focus on. Contracts are always between 2 or more persons, and no matter how many persons are there in a contract, all of them will be having certain rights, certain duties. Okay, it's not just that only one person is having rights and other person is having only duties. It's nothing like that. Both of them will be having rights and duties on both their parts. Okay, so they are obligated to fulfill all of them. Now, coming to the introduction of the Indian Contracts Act. So this is a colonial era act which has been which came into force on 1st of September 1872. So it is applicable to the whole of India, and as I have already told, only up to section 75 we are going to deal in first semester. Now, where do you think this law of contracts originated? Britishers came to India to govern here, right? So they also brought their thoughts, and for doing their business in a easy manner, they also developed certain laws here in India on par with England. Okay, so mercantile law is one such law, we can say, which originated in England and which was transported to India, I can say. So mercantile law deals with the law relating to trade, commerce, or industry. Okay, any law, any rules and regulations relating to trade, commerce, and industry was called as mercantile law. And any of the person who deals with trading business or commercial activities can be called as a mercantile person. So this was the parent law, we can say. Okay, this is the parent law. Based upon this, Indian Contracts Act was thought of, and it was introduced in India by the Britishers to make their work more easier as they were governing in India. Now, what was the object behind bringing this contracts law? Now, before contracts law in India, there was no such specific act in India which regulated contracts between two or more parties. Okay, it was only Britishers came in and they brought this act. So that no party is left unheard, or no party is at loss. Now, that is the first advantage, we can say. In case if there are, as I have told you, there are two or more parties in a contract, right? So obviously, let us suppose if one of the party is not performing what is written in the contract or what they have promised, then the other party is surely at loss, right? Now, in such circumstances, the what can be done? Then that party who is at loss, that is the aggrieved party, which we call it as in law, can go to the court. Then court will provide the legal remedies to such party who is at loss. It will provide compensation, or it will ask the other party to perform the contract. In such and such manner, the court functions. Court will come into picture only because there is a concrete law which has been put in place by the legislature. Okay, that is the Indian Contracts Act 1872. Now, so legal remedies are provided only when we go to the court, we can say. This is the first objective of why the law of contract was put forth. Apart from that, in this particular act, there is information relating to formation of a contract, how a contract can be formed between two or more parties, how it can be performed, and how can we say that it can be enforced, how is it enforced by law. Even that we are going to see in the law of contracts, the Indian Contracts Act 1872. Now, what was the purpose to put forth this contracts law in India? Now, as I have told earlier, there was no legal framework, there was no concrete law before this act. So it made them, necessary to come up with such a contract law so that disputes are not leading to complexities. Okay, so businessmen, mostly if you see, they don't want to waste their time and money by getting into disputes or any other such kind of things. So by placing this law of contract, disputes can be resolved easily because rights and duties are already specified. Therefore, half of the work is done easier if a statute is provided. That is the Indian Contracts Act. That is why Britishers came up with this comprehensive act, we can say. Now, the first term which we are supposed to acquaint ourselves with is contract. What is a contract? So here jurist Salmon has defined contract as an agreement creating and defining obligation between the parties. Now, as I have told you, contract is between two persons and it creates rights and duties upon both the parties. Okay, now coming to the next definition, which is given by Pollock. He says every agreement and promise enforceable at law is a contract. This is what Pollock says. Now, the Indian Contract Act 1872 also in its section 2 clause H defines contract as an agreement enforceable by law. Okay, any agreement which is enforceable by law is a contract. This is the most important definition which you will come across also in competitive exams. So let us understand this in a more with the help of an example. Let us suppose I am in need of 100 bags of rice. Okay, so I contact a trader. Rice trader. Each bag I want to purchase at 2000 rupees. Right. So we both come into a contract. Okay. So we both come into contracts. Remember, contracts can be oral as well as or it can be in written format. Okay. So here we have contracted for the delivery of 100 bags of rice on Monday. He is supposed to make the delivery and I'm supposed to pay him the price. Okay, now the contracting parties are the rice trader and me. We are the parties to the contract. We have framed certain rules and regulations. That is, I want the delivery only on Monday. There can be no delays. Okay, and the price we have negotiated came up till rupees 1500. We both have agreed to the so and so price. Okay, so this is the contract between we both of us. Okay, we both have agreed to this contract. So this is an example of a contract between the rice trader and me. If at all on Monday he is not performing the subject matter which is written in the contract, that is, if he is not supplying the 100 rice bags at the cost of 1500 on Monday, then I will take an action against him, because already the terms and conditions we have discussed, right? That is the essence of a contract, I can say. Okay, now let us understand what is an agreement. Both the terms, if you see, contracts and agreements, are used synonymously. Okay, but what exactly is an agreement? Agreement is nothing but a promise. Both the parties, even in agreement there are two or more parties. Okay, now I am promising to pay rupees 1500 for one bag. In the same manner, the rice trader is promising to supply me rice bags. Okay, this is nothing but I am making a promise, the opposite party is also making a promise. So agreement is nothing but a promise. Okay, for my promise there is a reciprocal promise, I can say, counter promise. So one needs to understand that not all agreements are enforceable by law. Enforceable by law means whether it is valid in law. Okay, when will the law regard such a contract as a valid one? Okay, it can be called as a valid contract only when it fulfills all the essential characteristics as mentioned in section 10 of the Contracts Act. Okay, now that is why we say all agreements are not contracts. Further clarity will be provided in the question which I am going to deal today. Now, let us first go through this definition of agreement, which is under section 2 clause E of the Indian Contracts Act. It defines agreement as every promise and every set of promises forming consideration for each other. As I have told you, every promise which I make and every promise the opposite party makes, where there is also exchange of consideration. Okay, I am promising that I will pay him money. Payment of money is nothing but consideration, called as consideration here. In the same manner, the rice dealer is parting away with rice bags. So for the trader, the consideration is the rice bag. So both of the things we are exchanging. So these are nothing but the promises which we have made which is nothing but an agreement between both of us. Now, when will this agreement be called as contract? It is only when it fulfills all the criteria as mentioned in section 10, which is the most important section. Based upon the checklist which is provided in section 10, then only an agreement can be called as a contract. Then only it takes the phase of the contract, we can say. Okay, now here is a small equation, I can say, of in an agreement there is an offer. Okay, I am offering to pay rupees 1500 for one bag. Okay, this is my offer, and if the opposite party is accepting my offer, then it will take the name of an agreement. Now, in the example which I have stated, my offer was that I need 100 bags of rice at so and so price. This is my offer, this is my proposal. If the rice merchant is agreeing, he needs to convey his acceptance in the at the earliest. Okay, I am the offerer. He is supposed to give his acceptance only to me in at the correct time. He is not supposed to give his acceptance after 2 days. Okay, then and there, if he is accepting and if he is agreeing to supply me, he is supposed to convey the same thing to me. Then we can say an agreement has been formed between the rice merchant and me. Okay, at the same time, you can see here that there is consensus ad idem present between both of us. Okay, consensus ad idem is a legal maxim which is nothing but two consenting minds, in the sense parties to the agreement are supposed to understand the subject matter in the same sense. I have stated my proposal stating that I want 100 rice bags at the rate of rupees 1500. This terms should be clear to the rice merchant as well. Okay, what I am understanding, he needs to understand in the same fashion. If he is not understanding in the same fashion, then we can't say that there is an agreement. Okay, agreement in the sense both of the parties should agree to the terms and conditions at the same time, at the same place. Okay, simply speaking, both of them should be on the same page. Okay, both of them understanding should be of the same level relating to the contract. If I am taking the subject matter in one sense, he is taking in another sense. Say I am thinking he is supplying me at rupees 1500, but that rice merchant is thinking to supply me at 2000, then there is no formation of the agreement, I can say. Okay, yes, now we'll be dealing with the most important question, that is, what are the essential features of a valid contract? Now, this question can be asked in another form as well. That is, the most important sentence which you will come across again and again in contracts law. That is, all agreements are not contracts, but all contracts are agreements. Okay, we will understand this statement in a better fashion. First, let us understand the definitions of both of these terms. Agreement is defined under section 2 clause E. At the same time, contract is defined under section 2 clause H of the Indian Contracts Act. As I have told, agreement is nothing but a promise. Every promise and set of promises forming the consideration for each other. Both the parties are promising to each other that they will provide something or the other to the other person. I am providing money, he is providing me with rice bags, isn't it? So, promise as well as consideration is present. Okay, there is an offer from my side and there is acceptance from the other side, which leads to formation of an agreement. In the same manner, when is a agreement called as a contract? Now, an agreement is called as a contract when it is enforceable by law. Enforceable by law is very crucial for an agreement to be called as a contract. Okay, now let us see how it is. As I have told, for an agreement to be enforceable by law, it needs to fulfill all the criteria which is provided under section 10. In section 10, there are certain points or certain elements which are to be fulfilled, then only we can say an agreement is enforceable by law. So the first element is proper offer and acceptance. When I am offering to the rice trader that I need 100 bags of rice at so and so price, I must state my offer clearly. I need to mention with clarity, and the same has to be communicated to him in a clear manner. Okay, everything has to be updated to him. At the same time, the opposite person, that is the rice trader, has to communicate his acceptance. If he is not agreeing to the price, he is supposed to bring that to my notice so that I negotiate, so that we both work out on the price or any other aspect. Okay, so the ultimate goal here is to give me the acceptance. So it is important that the rice trader informs me his acceptance before my offer collapses. Okay, this is very important. Offer and acceptance to be informed by both the parties to each other. This is the first essential in the section 10 which we come across. Now, it is not like only one essential is to be fulfilled for an agreement to qualify as a contract, but all the essentials are to be fulfilled. Only then a particular agreement can be called as a contract. Okay, that is why we say all contracts are agreements, but all agreements cannot become contracts. Okay, now the second one is intention to create legal relationship. Now, all agreements are, as I have told you, all agreements cannot take the name of contract. Let us suppose one of my friend have come from abroad. I am calling her for today's dinner at home, to my home. Okay, so I have called her for dinner. She has accepted my invitation, but she has not appeared. Okay, somehow she has got some urgent work. She has been somewhere else. Now, was the intention here in this transaction which I have explained right now to create a legal relationship? No, it was a social relationship, right? There is no legality in that, in the sense there was an agreement, both of us agreed. I offered her dinner at my place, she agreed that she will come to my place, but there is an agreement between both of us. But what she is doing, she has skipped this agreement. Can I take her to the court of law? The answer is no, because these are just social agreements between friends on things like this, for a dinner, for a coffee, or to go somewhere out. All these are social agreements, we can say. Okay, so the ultimate aim should be to create a legal relationship. So here the intention must be to create a legal relationship. There must be a legal duty to conform with. Now, the leading case law here is of Balfour versus Balfour. The agreement between husband and wife was held in this case law by the court that these are nothing but social agreements which are not legal agreements. Hence, this agreement cannot be called as a contract, is what the court held in that case. Now, the second essential ingredient, first we have seen, was offer and acceptance to be proper. The second one was creation of legal relationship. Now the third one is capacity of parties. As I have told, in a contract there are two or more parties, right? In an agreement or in a contract, two or more parties are essentially present. So the parties to the contract should be competent to contract, okay, in the sense they should be eligible to get into a contract, in the sense they should be of 18 years and above, okay, that is the main criteria. The second one is they should be of sound mind, in the sense all the mental faculties of that person to the, I mean those contracting persons should be in place, okay, they should not be insane, they should have the knowledge of right and wrong. Maybe you have understood what sound minded person is now, okay. The third one is he should not be declared as disqualified from law, okay. So contracting with the alien persons, in the sense those belonging to other countries, okay, if at all our country is having a war right now, it is disqualified by law, we can say. So contracting with such people is will not lead to the formation of a contract, okay. So the parties to the contract must be a major person, must be of sound mind, and should not be declared as a disqualified person, okay. Then we can say this agreement can be turned into a contract. Else, just imagine, I'll give you an example here. Let us imagine I contracted with a minor who is of 17 years. Then what actually happens? The contract is nothing but invalid in the eyes of law, okay. It is as though I have never contracted with that person. This is how the law regards. Or if I have contracted with a person who is insane, whose brain is not functioning properly, then this contract will be invalid in the eyes of law, as if I never contracted with him, okay. This is the consequences. Now the fourth essential ingredient is lawful consideration. Consideration, as I have told, it is nothing but something in return, right? Now the consideration should be lawful. Lawful in the sense it should not be exchange of illegal material, okay. Let us suppose let us suppose I have contracted Mr. A. I have told him to kill Mr. B and I will give him rupees 1 lakh, okay. So here the consideration which is present is a unlawful one, okay, because for the amount which I am parting with, that is 1 lakh rupees, Mr. A is providing me with an unlawful consideration, that is by murdering Mr. B, okay. So that is also important. Consideration should be lawful. The fifth essential ingredient is lawful object. The object of the agreement should always be lawful, in the sense it should not be not allowed by the law, okay. Should not be something banned by the law, or it should not defeat the provision of the law. It should not be against any legal proceedings, okay. It should not injure any person. It should not be opposed to public policy. What does all these things mean? In the previous example which I have given you all about the murder of Mr. B, if you say the object here in this particular transaction between me and Mr. A is unlawful, because here we are talking about murder. And is it forbidden by law or not forbidden by law? It is obviously forbidden by law. It is against the law, right? So this agreement is invalid in law, we can say, okay. It is not, this agreement does not have a lawful object, it has an unlawful object. In the same manner, there is another example which I want to give you all. I have joined hands with a thief so as to commit a robbery at one house. Okay, we have robbed Mr. B with jewels and all the precious ornaments and cash. Agreement between Mr. A and me is that we both will commit this robbery and divide all the money and the precious materials between both of us. Okay, so do you think the object of this agreement between the other thief and me is a legal one? No, not at all. It is not at all lawful, and also it is against the law. That is why this agreement cannot be taken to the court of law. If in case I am not providing him with 50% of the things which we have robbed from that person's house. Okay, so the agreement is void between me and the thief, in the sense it is invalid because the object of the agreement is unlawful. So law doesn't protect such unlawful agreements. Therefore, we say that such an agreement cannot become a contract in the eyes of law, which means it is not enforceable by law. Now, the next essential is free consent. As I have given the example of the rice trader and myself, in this contract between him and me, let us imagine the rice trader agreed for rupees 2500 per bag, but I have forced him to supply at a low price, that is rupees 1500, thereby causing him a loss of 1000 rupees per bag, isn't it? Now in this transaction, if you see, there is no free consent of the rice trader. I have forcibly made him to supply me rice at low price which I am stating, and not the price at which he wants to sell me. Okay, so here in this transaction there is no free consent of one of the party to the contract, here in my example the rice trader. Okay, now here the law says that there should be consensus ad idem, which I have explained earlier, that both the persons to the contract should have identity of minds. Both should understand the subject matter, the terms and conditions of the contract in the same sense. Only then we say that a contract has come into place. There are circumstances where free consent is not present in the contract. Okay, like in the example which I have stated, but the more serious example could be, let us imagine you have purchased one building for rupees 5 lakhs while its worth is 5 crore. Okay, you have forced the owner to sell you at a price. How you have forced him? You have threatened him. Okay, so there is a threat to his life or his loved ones. Okay, that is why he has put his signature on the legal documents. Okay, so here he is not signing the papers out of his free will. You are actually threatening him. So here we can say the person doesn't have the free consent in the contract. Okay, so he is under coercion. Also, there is an instance of undue influence. If at all in any contract there is coercion, undue influence, or if somebody is defrauding, or if there is a misrepresentation present, if the facts are not presented as it is, okay, if there is any mistake, then we can't say that there is free consent. In the sense, the contract which is valid in all other aspects may still fail because there is no real consent by one of the parties, one or both of the parties. Then in such circumstances, it can so happen that he can go to the court of law. In such circumstances, the person who has signed the documents under force can go to the court afterwards and then say that he has contracted only because of some pressure which has been created. Okay, so yes, there should not be, for a contract, for an agreement to be called as contract, there should not be any sort of force, any sort of pressure created on any of the parties. They should be coming together to form a contract with their free will. Okay, yeah. Coming to the seventh essential ingredient, that is agreements not expressly declared void. So any agreements which are against the trade or the marriage or any legal proceedings, okay, such agreements cannot be called as contracts. Okay, they are invalid since the beginning. Let us suppose X has promised, I have promised to marry Y only. Okay, if I don't marry Y, then I am supposed to pay him 1 lakh rupees. Okay, this is the thing. This is the agreement which I have made between myself and Y. Now, I have married not Y but somebody else. Then what is the scene there? Y cannot take me to the court of law because this agreement is against the marriage, right? So any sort of agreements which is in restraint of, in the sense against the trade or against the marriage or against the legal proceedings, okay, so all such agreements are void, in the sense invalid since the beginning. One cannot go to the court in such agreements. Okay, now the eighth essential ingredient is the certainty of meaning. Terms and conditions which are written in the agreement should be valid, in the sense they should be certain, which can be performed, which are clearly mentioned. Terms which are uncertain, which are unclear, cannot be a part of an agreement. Everything in a contract should be specified in a layman language, precisely, to the point, okay, without any confusion. Such agreements can qualify to become a contract. Now, the ninth essential ingredient is possibility of performance. Let us suppose I have made an agreement with Mr. A that I will put life in a dead body and he will provide me 2 lakh rupees if I put the life in a dead body. Okay, do you think performance is possible in this particular agreement which I have come with Mr. A? Not at all. Which I have formed with Mr. A? Not at all, right? So here what happens? The performance which is written in the contract, the subject matter of the contract should be performable. Okay, it should be capable of performance. If it is not capable of performance, then it will destroy the essence of the contract. It will not become the contract itself. Okay, here is the example. It states that X agrees with Y to discover treasure by magic. Do you think it is possible? Not at all. Therefore, this agreement is invalid. Therefore, cannot, at any circumstances, it will not become a contract because it is an impossible act. The final essential ingredient is legal formalities must be completed so as to make an agreement into a contract. Okay, legal formalities. We say that contracts can be oral or it can be in written format. Okay, but when the law itself provides certain formalities to be complied with, such as registration or witnesses signature or stamping, all of these things, if the law itself is specifying, then we are supposed to comply with such formalities. Okay, so in instances where there is a sale of property or mortgage of property, or if there is a lease of property, okay, in case of a landlord giving his house on rent to the tenant, then there should definitely be a contract present which is in written format, and also all the essentials are to be fulfilled. That is, it must be properly signed, it must be properly stamped, it must also be registered, we say. All such things are to be complied with. Also, if there is gift of immovable property beyond certain amount as specified in Transfer of Property Act. All such things are to be reduced to writing, okay, so that the rights and duties of the parties to the contract are clearly mentioned, because there is huge money involved in such contracts. So as to protect the interest of both the parties, it is essential that a written document is placed between them, and both the parties sign, and also their witnesses sign, okay. So when the law itself focuses on registration of documents, then compulsory registration has to be made. Oral agreements or oral contracts cannot be made. So upon fulfillment of all these 10 essential ingredients, as mentioned in section 10 of the Indian Contract Act 1872, then only we say that an agreement qualifies to become a contract, in the sense agreement is enforceable by law, therefore becomes a contract. If any of the single essential is not complied with, not followed, then it cannot be called as a contract, it will remain as an agreement only, okay. And you cannot take it to the court of law, because what can be taken to the court of law is only a contract when it has legal recognition, okay. A legal recognition is provided to the contract papers only when all the essential features, as we have mentioned now, are complied with. This is the most important answer. All agreements are not contracts, but all contracts are agreement.